What would happen if you got into a serious car accident tomorrow or were diagnosed with a sudden illness and couldn't speak or make decisions for yourself? Would your family be ready to step in and help? Would they even be allowed to? In Washington, like in most states, incapacity doesn't just bring emotional turmoil, it brings legal paralysis. Banks freeze your accounts, doctors can't legally share information, your loved ones might have to go to court just to manage your care or access your finances. And here's the scariest part. This doesn't just happen to elderly people. It happens to young parents, to healthy professionals, to people who meant to plan ahead but just never got around to it. The good news, with the right tools in place, you can protect yourself and your family from chaos during crisis. Hi, I'm Jason Gray, estate planning attorney in Washington State. And today we're talking about something that's uncomfortable, but absolutely essential. What happens if you become incapacitated and how you can legally prepare for it? I'll walk you through the exact documents you need here in Washington State, common myths that leave families vulnerable, and how you can take simple, powerful steps to ensure your wishes are honored and your family isn't left struggling. Let's get into it. In legal terms, incapacity means you can no longer make informed decisions for yourself. This could be because of a stroke, a traumatic brain injury, a mental health event, or progressive conditions like Alzheimer's. And when this happens, the law doesn't assume your spouse, your child, or your parent automatically gets to decide for you, not in Washington. Instead, unless you've created specific legal documents, your family will likely need to file for a guardianship or conservatorship through the court system. That process can take months, it's expensive, and emotionally exhausting. Worse, it can lead to family disagreements about who should take control and what decisions should be made. The documents you need in Washington: durable power of attorney for finances. This is one of the most important legal tools for incapacity planning. A durable power of attorney, or POA, lets someone you trust manage your finances if you're no longer able to. This includes accessing bank accounts, paying bills and taxes, handling investments, managing property or real estate. The key word here is durable. That means it remains valid even after you become incapacitated. Here in Washington, it must meet the requirements of RCW 11.125, which outlines proper execution and default powers. Now, here's where most people get tripped up. Generic POA templates often don't work. Banks might reject them if they don't have the right language. To be legally enforceable and useful in real life, your POA must be specific, up-to-date, and ideally prepared by an attorney familiar with Washington law. Healthcare directive and medical power of attorney. You've probably heard of a living will. In Washington, we refer to this as a healthcare directive governed by RCW 70.122. This document allows you to state your wishes about life-sustaining treatment. It answers questions like, do you want CPR if you're terminally ill and unconscious? Would you want to be kept alive on a ventilator if recovery is unlikely? But a healthcare directive doesn't cover everything. That's why you need a medical power of attorney, sometimes called a healthcare agent or proxy. This lets someone else make all your medical decisions if you're incapacitated, not just end-of-life choices. Things like choosing between treatment options, authorizing surgeries, managing hospital transfers, or long-term care. Without this document, your family could be forced to ask a judge for legal authority during one of the most stressful times in their lives. HIPAA authorization. Now, here's a document most people overlook, but it's crucial. A HIPAA authorization allows your chosen decision makers to access your private medical records. Even with a healthcare directive, Doctors and hospitals in Washington can refuse to disclose information unless you've signed a HIPAA release. It doesn't matter if it's your spouse or your child. Without written permission, they may be shut out of conversations about your care. This document doesn't give decision-making power, it just allows information sharing. But that access can be the difference between fast care and dangerous delays. Revocable living trust. If you own a home, have investment accounts, or run a business, you should strongly consider creating a revocable living trust. Here's why. If your assets are in your name alone and you become incapacitated, even with a power of attorney, managing them can be complicated. But if those same assets are inside of a trust, your successor or backup trustee can immediately take over and manage everything seamlessly. There's no court involvement, no frozen accounts, just continuity. This is especially important if you're single and don't have a joint account holder. You want privacy. Trusts don't become public records like wills do. You're planning for long-term care needs or Medicaid. The trust is like a safe, and funding it means putting your valuables inside. Just having a document isn't enough. You need to retitle your assets properly to make it work. Guardian nominations. If you have minor children, this might be the most important decision you ever make. Washington law allows you to name a standby guardian in case you become incapacitated. That way your children aren't left in limbo or, worst case, taken into state custody during a crisis. You can name a guardian in your will, but to cover incapacity, you'll also want to file a standby guardianship designation under RCW 13.36. This gives peace of mind that your chosen person will care for your kids, not whoever the court appoints. Myths and mistakes, don't fall for these. Let's clear up some common misconceptions. My spouse will handle it. In Washington, your spouse can't automatically access individual accounts, make healthcare decisions, or sell jointly held property without your permission or proper legal authority. I'm young and healthy. This doesn't apply to me. I've worked with clients in their 30s who had strokes. With no documents in place, their families spent months in legal limbo. The government will step in and help. Yes, but through the court system. That means fees, delays, and public records. And judges don't always appoint the person you would have chosen. These documents are powerful, but they're not set it and forget it. Every 3 to 5 years or after a major life change like marriage, divorce, new child, or medical diagnosis, revisit your plan. Make sure your agents are still the right people, your documents reflect current Washington law, your assets are still properly titled. And here's one more tip. Store your documents in a safe but accessible place. Let your loved ones know where they are, give copies to your agent, your doctor, and of course your estate planning attorney. You can also add what's called a personal letter of intent, a simple note explaining your values, your wishes, and what matters most. It's not legally binding, but emotionally it's priceless. Take action before crisis hits. You don't need to predict the future, but you can absolutely prepare for it. Incapacity can happen without warning, but with the right plan in place, you stay in control even when life feels out of control. So here's your next step. Click the link below to book a free consultation with our team. We'll walk you through every document, help you tailor it to Washington law, and make sure your family has the protection and clarity they deserve. And if you found this video helpful, check out my next video. YouTube thinks it'll be right up your alley.